Good evening. Today is June 24, 2025, and this is Reactionary Docket, Episode 2, Armageddon Countdown. If you missed Episode 1, we covered how the Department of Homeland Security abruptly shut down 3 statutory watchdog offices and got sued the next month. Tonight, the lawsuit leaves first gear and accelerates toward its first real test, the preliminary-injunction fight. Let's rewind the docket in 30 seconds. March 21st, DHS issues a memo dissolving the Office for Civil Rights and Civil Liberties, the CIS Ombudsman, and the Office of the Immigration Detention Ombudsman. April 24th, 3 public interest groups sue. May 8, they move for a preliminary injunction, court docket number ECF 15-1. And a few hours ago, on June 24, Judge Ana Reyes set the response clock ticking. On May 8, the plaintiffs filed a 47-page motion backed by 18 declarations, border shelter directors, immigration attorneys, a former CRCL deputy director, and multiple whistleblowers. 2 samples. Lillian Serrano of the Southern Border Communities Coalition writes, "Since the shutdown, our hotline escalations receive no acknowledgments, leaving migrants to sleep outside without blankets." Former CRCL Deputy Deborah Fleisacker states, "A single policy advisor cannot replace a 100-person oversight office any more than one firefighter can replace a station." Together they argue that every day the offices stay dark, detainees, visa applicants, and whistleblowers suffer harms no money can fix. To win a preliminary injunction, you have to run the 4-factor gauntlet. Likelihood of success on the merits. Does the law clearly favor you? Irreparable harm. Will you suffer injuries that money cannot later repair? Balance of equities. Does halting the defendant hurt them more than it helps you? Public interest. Will society benefit or suffer if the court intervenes? Today, Judge Reyes gave DHS 7 days, until July 1st, to address each factor, then penciled in a hearing for July 9th. Under her standing order, trial dates move only for, quote, the legal equivalent of Armageddon. Translation, those deadlines are real. Managerial discretion sidebar added. What will DHS argue? Expect 3 themes. Managerial discretion. Agencies usually control their own org charts. DHS will cite cases like Lincoln vs. Vigil, which let an agency reallocate funds absent clear statutory commands. Redundancy. DHS says oversight isn't gone, just absorbed by component offices. Public interest. Streamlined enforcement, they argue, protects national security. The plaintiffs counter that Congress used mandatory language. There is established within the Department an Office for Civil Rights and Civil Liberties. Courts call wording like shall establish and there is established non-negotiable.
What happens after July 9th?
If the injunction is granted, DHS must at least restart the complaint hotline and begin rehiring while the lawsuit continues. If denied, the offices stay dark until final judgment or congressional action. Plaintiffs could appeal immediately, but injunction appeals move slower than district court discovery.
Viewer FAQ added.
2 quick viewer questions. Q. Could Congress just pass a rider tomorrow and force DHS to reopen the offices? A. Yes, but appropriations riders move with the fiscal year budget. That means waiting until at least October unless a supplemental bill appears. Q. Does this case block immigration enforcement? A. No. The plaintiffs aren't asking to stop enforcement, only to restore the independent office that checks civil rights violations.
Call to action unchanged.
Every filing, motion, declarations, Judge Reyes' order, is 1 click away on Court Listener. The docket link is in the description. Read the motion, skim the 4 factors, and decide which side looks stronger. Subscribe and hit the notification bell. On July 1st, we'll be back breaking down DHS's brief line by line. Until then, keep the watchdogs awake.